spent preparing cases and making sure we're talking about the cases before we even file them. So a lot more concentration on that. I can talk about it later, but we have certain attorneys that are very, very passionate about a specific type of case. And I found that makes them really more committed to preparing that case, to looking into the information before it's filed, to carrying it all the way through, to exchanging good information, and for really, real quality work from our office. Such as, some of the examples are, there's two attorneys that, among other things that they've chosen to take on, such as crossover or a 0 to 5-year-old children group, just in addition to their regular caseload, 2 attorneys that do most of the termination of parental rights. 1 attorney that does her entire caseload is the returns from the Juvenile Assessment Center. And the benefit of that is that, so there's 1 attorney that's reviewing all of the police reports that come through to determine eligibility for the Juvenile Assessment Center. And if one is not successful and needs to be referred back, those cases go to the 2nd attorney that then has all of that information and is very competent and understanding of what would have transpired at the Juvenile Assessment Center, who are the contact people there, what information do I need to provide as far as discovery for defense, what information do we already have that we can give the court for disposition, and very useful information. 2 attorneys whose entire caseloads, and I'm talking about over 200 cases each, are gang-involved juveniles, that they are participating in community meetings on a weekly basis and have knowing information about these youth, what's the status of their court case, what's the situation surrounding the entire case. We have drug courts, as some of you are familiar. There's teams most of the teams are on the child welfare piece, but as you know, you're here today for Operation Youth Success, and we have Juvenile Detention Alternatives Initiative. There's working subgroups and committees that come out of both of those initiatives that people participate. So that's just a broad overview of what it is that we're doing. Like I said, I've been there 20 years, and I can definitively say this is an outstanding staff, both the attorneys and the support staff that we have, that I'm telling you, never stop typing, never stop figuring out information, and they have to be very competent in what it is they're doing. If that attorney's running to court, coming back, checking in, there's people waiting on us. We're in the middle of a process. We're the last step before it gets to the judge. But there's a lot of people and a lot of agencies that are depending on us along the way. Some of those agencies you're hearing from today. Omaha Police Department. There's many occasions that we're fielding calls and working through cases with the Omaha Police Department. Juvenile probation, many calls and conversations that we're having with juvenile probation, discussing things. We have on the child welfare end, obviously Child Protective Services, Nebraska Families Collaborative. Douglas County Sheriffs are waiting on us. If we get an affidavit for removal and we give them that information, we're that piece of that puzzle. And everyone's waiting for the finished product that we're bringing over to the court for the date, the time, the filing signature, so that we can get it off to everybody. So it's very, to be honest with you, when support staff leaves, and they are generally not able to leave on time, they're exhausted. And they say, we'll do it again tomorrow. So it does not stop at 4:30 either, I want to tell you that, especially on the child welfare end. There could be that CPS is going out on priority 1 calls any time of day or night. And even if they're going out in the morning, by the time they talk to their all their collaborating people that they need to talk to, they might not make the determination after it's staffed within their agencies. As soon as they can get it all together and make that determination, might be 4:29. So we have to make sure that we have avenues that we can get those affidavits in the evenings and the weekends electronically. Sometimes last weekend, Judge Thomas went to the sheriff's office on 156th and Maple. Sometimes the sheriffs go to the judge's office. Sometimes the judges do electronically. Sometimes it's them going to Project Harmony. But this is, again, this is important for you to understand that this is 24/7, that this is going. So I mentioned that we have the two avenues. Because I think mostly we're here on the juvenile justice, I'll just briefly first talk about the child welfare end. In the state of Nebraska, there's only one type of entity that can do a removal besides a judge's signature. So absent a court, the only agency that can remove and place into protective custody is law enforcement. And that's different in some states. And law enforcement takes that responsibility very, very seriously. The statute is an exigent circumstance. It's an emergency, it's imminent danger. If they don't see that, but they still needed to respond, they refer the case to Child Protective Services, and that is screened through the hotline. It can be not accepted, or it can be accepted. If it's accepted, then they take it as a priority 1, a priority 2, or a priority 3. And the difference there is the response time. If law enforcement does the removal, and typically law enforcement removals are a crime that they're walking into, a shaken baby, a sexual abuse, a filthy home, a child that literally has no parent. Those are some of what we see. Those we have 48 hours to get a court order. So if it's Friday night at 8 o'clock, then we're getting a court order from a judge by Sunday at that same time of day. Then we have to Monday to file the paperwork. Obviously, most of our removals are from Omaha Police Department, but there are other law enforcement jurisdictions within Douglas County that obviously have that same power. We have, when the cases then get referred on to Child Protective Services, if they're accepted, they may determine after their investigation and assessment to send us an affidavit of removal. Or they may determine that this is something that could be worked non-court. And as you all know, there's a very high number of cases going non-court over the last several years in an attempt to provide reasonable efforts and out-of-court services to families. It may come to it that NFC needs to do an affidavit that there's a pretty imminent safety issue at this point and risk of harm. Those affidavits are steady from Child Protective Services and from Nebraska Families Collaborative. And what we've done to collaborate with them, because we're moving so quickly and we may be literally working on 10 in one afternoon, is we have strict instructions in terms of what the subject line is supposed to say, so we're flagged that it's an affidavit in the family name, and there's a worksheet that has to be completed with the names and the addresses and what's the request. What are we asking for? Do you requesting a sheriff pickup or you're not requesting a sheriff pickup? Are you requesting placement include the home? Are you requesting placement exclude the home? Those are our decisions, but we need to have those on the top of the affidavit so that we know what we're doing, what we're reviewing, what's the request. So we can move on that. All that information goes quickly to the Douglas County Sheriff's Office so they can already do their history before we even have the signed order. If this order gets signed, sheriffs are thinking, am I going to be walking into a home where there's a warrant for domestic violence on one of the parents? Sheriffs want to go to the schools versus the home for pure safety. When they pull up to a home, they don't know who's Johnny, who's Ricky, who's the cousin, who's the dad, who's the mom, and they're not going to necessarily be told the truth by the people on the premises. It can get very unsafe for the family and for the deputies. So we try to expedite those cases to the school time so that it's a less confrontational removal and less traumatic for the children that are involved. Once those cases come through the system, I'm sure Sean explained, there's a record of those in terms of that there's a filing now in the child welfare system, and those cases are heard in front of the judges. If a delinquency case comes along, then on one of those juveniles, it'll be flagged. Because our case management system picks up every single juvenile who is any street release at all. We'll pick it up about 24 hours later. And then our case management system will show, we input any truancy referral that's come across our desk. And then we hand input any purely status filings other than truancy, which is very infrequent, and I can talk to you about that. That data is exchanged with CPS to determine does anyone flag for crossover, and then it goes over to the crossover team for them to do their collaboration, and we have somebody on the crossover team, 2 attorneys actually, that trade off The second one, I couldn't get her off of it. I said, I have someone to do this. This is her role, but she absolutely loves it so much. On top of her full caseload and not reducing any number of TPRs we're referring to her, she wants to remain participating in that crossover team. So lastly, 1184, if you hear that in the community about our office, that's a statute, a law from 1992, wherein the legislatures determined it would be best to have Child Protective Services and law enforcement work and talk with each other, so they put them in one building with some medical personnel under the umbrella of Project Harmony. You all know where that's located now, on about 119th and Q. And there's several teams. There's investigative teams, there's treatment teams, there's teams for 0 to 5-year-old children, etc. In terms of all the parties around the table, and supposed to be giving a team perspective, how you can help each other out, what resources might be available for this family that somebody else didn't think of. That's the point of that. Any questions? I was real brief on that, on the child welfare system. And I do want to follow up on that real quickly. If we don't locate a juvenile on those cases where we're doing pickups, because that happens sometimes, parents abscond with them, where everybody on the email group gets a reply out. We found the children, or we didn't find the children, and here's who can help you this evening, or let us know if you find them in the morning. And we stay on top of that. The most recent case took about 3 to 4 weeks with Potawatomi County Attorney's Office helping us, Council Bluffs Police helping us, Douglas County Sheriff's helping us, OPD helping us, and everyone together. It was within the last 7 days that those children were located. So on the juvenile justice end, we get police reports. They're street releases. As you all know, since the new law, they're not tickets anymore. There used to be tickets for 16, 17-year-olds, and they started in the adult court system. That was confusing in itself. Now, anybody under the age of 18 will get a street release, except traffic, and DUI is included in traffic. So those cases could come to us, but generally speaking, the traffic for the most part stay adult, because juvenile court's supposed to be rehabilitative. We don't necessarily have processes in place for rehabilitation on traffic offenses. Some DUIs do come to us, and obviously we're going to look at the chemical dependency issue. So by having one attorney that's reviewing all of those police reports that don't have a pending open docket, we get some consistency. That same attorney not only does the delinquency reviews, but the truancy reviews. And I wouldn't really, I'd have to guess at the percentage of cases, but well more than the majority of cases that come to our office are given the opportunity for the Juvenile Assessment Center screening. Yes?
Back in like 2008, if I'm correct, wasn't there was a law passed that would give, I think it was for Douglas County, to do a civil citation program wherein the police could issue a civil citation and then you could report directly to the JAC to, get to those quicker, install services quicker, and assessment. Are there any talks about pursuing that? I mean, I think the law passed and everything kind of fizzled.
I think the reason that, and this is just my opinion obviously, but the reason it fizzled is because the law was also clear that these are not arrests. And so the civil citation idea, while for those practicing in the arena of juvenile justice, appreciated the idea that a citation, a civil one, takes away the implication of arrest. We never viewed it that way, and the statute was already clear that they're not arrests. And they were a little bit, now they're being sealed on a more regular basis, but they could be sealed at that time as well. So that's why I think the street release form, being that it's not an arrest and it's anything, if a juvenile were applying for a school or for a job, they would not need to indicate that they were arrested, because the statute was clear that street release is an arrest. As far as the officer taking them straight to the Juvenile Assessment Center, I don't think that went anywhere, and Commissioner here said, but that would entail a 24/7, because some of the street releases are coming at 2 in the morning or midnight, that would be a completely different run program than our current Juvenile Assessment Center. And
I don't think it was a release to JAC. It was citation had a date. You need to go to the JAC on this date for an appointment, rather than going to the county attorney.
Right, the problem with that is that we have to screen it first, because there are a significant number that are null and crossed. whether it be delinquencies or whether it be truancies. So we don't even want to refer those over to assessment because we think it would be unethical to refer a case that we can't prove beyond a reasonable doubt, even to start that process of something that could end in a filing. So we are, I can tell you, we used to be even quicker at it than we are now, and the reason for the delay is the crossover street. But we are dedicated and committed to moving almost as quickly as if it had gone straight to the jack. But again, we have to, when it gets, it'll show up on case management, the truancies have to be put in, but we have to wait for that list, and then it goes to CPS, they check every single name on it, and we get their list back, and then we make our decision. So it slows up the process a little bit, but that's kind of why that didn't happen, is because we want to screen out what can we immediately eliminate. What is appropriate for the Juvenile Assessment Center? What do we already have an open docket on? Some of the juveniles we're getting street releases on, they already have 4 dockets. So we may choose to nolly cross that. We may choose to hold it. We have a list, not very many, of some attorneys at the most. I think one attorney has a little more because she has the Juvenile Assessment Center returns. Just holding a few to see, do they do well in their open dockets. So we definitely want to filter through those and only send to the JAC the most appropriate cases for assessment. Okay. I need to look down for 1 second to think of where we were. Okay, so we talked about the cases that are then screened. Some of them already have open dockets, and so that might not go to the JAC. We might do the nollie pros. We have cases, so I want to get, this is really a guess, but about 90% of the cases are going that direction, a street release, maybe even more, and being nollie pros or refer to the Juvenile Assessment Center or some file. The other ones are coming through the intake process. So the intake process is law enforcement determined that this juvenile is a danger to self, danger to others, or flight risk, and they are booking them and they're requesting continued detention. That is different than an adult that's being booked. And there's 1 year that I went to 40 roll calls. Sometimes they're at 6 in the morning, sometimes they're at 10 at night because it depends on the shift time. And there's about 36 different units that are working on uniform patrol to talk about the difference. So if you're an adult, that you're booking an adult, that's it. The whole idea of that is you're incarcerating them. They may or may not bond out. But for a juvenile, it's different because, for instance, OPD has, if you're on a felony, you have to be booked. But that's just paperwork issue. That's how our process of paperwork and where it goes and how it's put on computers. But the law doesn't say, nor do any policies, that a felony juvenile that's being booked by law enforcement, that law enforcement has to ask for continued detention. So it's a 2-pronged thing that we continue to remind everybody. And I think it's everybody has a very good, solid understanding of it. In Omaha Police Department and the law enforcement agencies in Douglas County. So on the list in the morning that is provided by intake probation, at the bottom there might be some listed law enforcement book and release. For instance, a 14-year-old burglary charge, has not done it before. They're booking because it's a felony, but they're taking back home. They're not asking for continued detention. We'll review those police reports, and this is where it kind of benefits. If we went strictly civil citation, and since this is a booking, this wouldn't get to go to the JAC. We may send it there. We very well may send a 14-year-old on a burglary charge, depending on his history, to the JAC, if nothing else, for the screening and assessment, and then let's talk about it again. But there are opportunities for felony cases to go there. You might also see on the list where law enforcement asks for detention, and then intake is the next part of the statute. Law enforcement is supposed to deliver the juvenile and all relevant information to the intake probation officer. For the intake probation officer to use the tool to consider all the information and to make a determination about whether or not there'll be detention, and if not, secure detention, an alternative to detention. Years ago, we had a lot happening over the phone. It's not appropriate. There's too much information. The only interviews happening over the phone, to my knowledge, are the juveniles who are found at school with warrants, and I can talk about that in a minute. The SRO has them in their physical custody, and by agreement of law enforcement and intake probation, they'll do that over the phone because of the great likelihood that there was some miscommunication, there's some wrong address, et cetera, et cetera, et cetera, and this can be resolved, the warrant can be resolved, get the new address, the phone number, release them back to school, get the judge the information, the matters reset for them to appear. Other than that, if it's not that type of situation, we used to have where the police officer would call and say, I have such and such in my cruiser, this is the charge, and we're requesting detention. And it could have been 1 or 2 in the morning, and the response back would be, that's not enough, you have to street release them. Okay, intake probation cannot advise a police officer how to book a release or what to do. When we're doing all these collaborations, it doesn't mean that you can go outside the law and direct another agency to do something, and I can tell you for sure it was happening on a regular basis. And the officer took that to mean I have to do what they say, and they would do an actual street release form on, for instance, a felony burglary. You cannot do that in OPD. Okay? You have to book. Their policy is on a felony, you have to book. You don't have to ask for detention, but you have to book. So what we found out years ago is a lot of the actual paperwork was not being processed and getting to the agencies it needed to get to for review because of the miscommunication and the information that was being given by the intake probation officer when law enforcement officer called them. We have it documented in police reports. Hence the roll calls and the working and talking together about how do we do this best. So the police officer has been trained to say, if it's not someone sitting in school with a warrant, I have this person, I'm heading to youth center, I need you to meet me there. They have to make, if they're making a request of detention, they have to actually say that, and then the screening has to be done, and it will be on the list the next day about what the decision is. Okay? So we've come a long way with fixing communication, and it's evident on that list on a daily basis how we have everything in order in terms of how that's supposed to go. If intake probation determines on a case that law enforcement asks for detention, that they're going to detain, or an alternative, we're the next step, we're the third piece, our county attorneys across the state, this is our statute. We can say, we're not going to file this case, so they need to be released. Or we're going to file this case, but we're not asking for detention, so we need to let intake know and the court know there's not going to be a hearing on this one today. Only if we are asking for some form of detention does it then go in front of the court that day. And we have to have our petition filed and ready to go. We use the intake interview information, we use the affidavit from the police officer about the facts, we use the history of the case, and we go in there, we make a recommendation that may or may not be the same as intake probation, and the judge's decision may or may not be the same as intake probation. That all depends. That's when the detention hearing is. After that, we continue with the case, arraignment hearings, pre-trials, adjudications, which are trials, review hearings, dispositional hearings, I forgot that, I'm sorry. Motions to revoke. The law now says if we want to commit someone to the Youth Treatment and Rehabilitation Center in Kearney for boys, Geneva for girls, we have to file a specific motion requesting that. We have had, the majority of the deputy county attorneys have visited the Kearney campus. Whoever has when I was talking about specialized, there's one attorney who takes every single sexual abuse case, whether it's on the child welfare side or the juvenile justice side. He is extremely well versed in those cases and been in those facilities and following through on those teams, the sexual abuse team at 1184 Project Harmony. I heard some truancy cases. I'm down to 4 minutes. I attended a meeting with Don Klein at least yearly, sometimes it's 2 or 3 times a year with all the superintendents from each of the districts that are in Douglas County, and that goes very well. So we have a continued working relationship with all of them, work out any little issues that come up. We also meet on a regular basis with their superintendent of OPS and their lawyers, and Don Klein and myself, to stay up on any issues that may come up. I'm sure Sean talked about, we've been for 20 years trying to help families that are calling or walking in that need help. And we have used Region 6, we've used a program, many different programs, and can never thank the Juvenile Assessment Center and their staff enough for assisting these families. We are not therapists, and we're not assessment specialists in our office. We're attorneys. And Assessment Center is able to talk through with these families, what are the issues, who are you already connected with, etc., to really help at least 150 families that literally have called this year and call every year, begging, crying for assistance. And they are getting assistance. And if something different needs to happen, we are talking about it. I can tell you this, that even in an example yesterday, a juvenile that we've been very worried about, that has been missing, was shot. We don't know where she ended up. The parent's not around. The missing juvenile report's out there. Our warrant is out there. All of a sudden decided for some reason that she wants to turn herself in yesterday. We have no idea what happened to her, that all of a sudden she's desperate to get some help. And everybody was prepared. That county attorney, like I said, that has a passion for those kind of cases, already was all over it. The court and everybody, intake, probation, worked together to figure out a way that she could go home with that adult that brought her in, but let's get her into HH custody for that medical exam, for the trauma-informed psychological, get her everything that she needs. Okay? These are the things that are going on every single day. The girl the other day that one of the judges ordered the guardian ad litem, which you really can't do, to file a missing juvenile report. Just so you know, a missing juvenile report, I have 60 seconds, it's a case. It's a missing person. Amber Harris was a missing person. That's the same situation we have with kids that run away and are reported missing. It's on a national registry. So on the list, Heather can tell you right now, one's in Colorado, one was in Washington, one was in, I can't remember the third state, that they get found. They don't see our warrant. Our warrant's just in Douglas County. Nobody's looking for them on our warrant. They're seeing the missing. So then probation has to work with the court on how to get them back if the court wants to extradite them back. But the judge ordered a GAL to make this one report on a missing on a girl. We have no idea where she is. They actually took it. She surfaced the other day. Her mom's flying in California. She's 16. She's pregnant. She's couch surfing. And everybody worked together to get that, make it happen, exactly what she needs. So I just want everyone to keep in mind that some of these warrants and missings are not to the goal of locking anybody up. It's to find them and figure out what is best in their best interest. And our office, I can tell you, is extremely committed to doing that on behalf of juveniles. Thank you.